All rise. The customer specialist chamber is now in session. Please be seated. Good morning. Welcome. Court officer, can you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you, Madam Court Officer. Can I please ask the parties, the Victims' Counsel and the Registry to introduce themselves, starting with the Specialist Prosecutor's Office.
Good morning, Your Honors. Good morning, everyone. The prosecution is represented today by myself, Cezary Michalczuk, prosecutor, Silvia De Ascoli, associate prosecutor, Filippo De Minicis, associate prosecutor, and also Alex Whiting, deputy specialist prosecutor. Today with us, the court, the case manager is Julie Mann. Thank you.
Thank you. Please, Victims' Counsel.
Good morning, Your Honours. Good morning, everybody. Victims' Counsel is today represented by myself, Annie Poos as counsel, and Marie-Pierre Barbeau as senior legal associate.
Thank you. Okay, now the defense, please.
Good morning, Your Honor. My name is Julius von Bonnet. I'm representing Mr. Mustafa as lead counsel. Here is also present Mr. Shala, my co-counsel, and Mr. Fatmir Pillai, the investigator. Mr. Mustafa is on remote, also present. Thank you very much.
Okay. Thank you. And I turn to the registry, please.
Good morning, Your Honours. My name is Ralph Roach from the Registry. Thank you.
Thank you. And for the record, my colleagues for trial panel 1 are Roland Dekkers, Gilbert Biti, and Vladimir Mikola, and I am Mappie Veldfolia, presiding judge for trial panel 1. Yes. Before we revert to the testimony of witness 3593, I would like to explain briefly the schedule for today. It is in our intention to finalize with the examination of witness 3593, and then to start tomorrow with the examination of the next witness. So that's the plan for today.
Your Honor, may I just say that tomorrow the accused will be present in the courtroom.
Okay, thank you.
And that is going to be probably always with that particular witness.
Thank you for informing the panel. Good. Court usher, can we please usher the witness into the courtroom? Mr. Mustafa, do you hear me?
Yes, Your Honor.
To inform you that you are now in the courtroom seen through a big screen. So that's the way you are participating with us today.
Yes, Your Honor, thank you.
Mr. Witness, good morning.
Good morning.
How are you doing today?
Okay.
Mr. Witness, we will continue with the defense posing questions to you. And I will now give the floor to the defense counsel to complete its question. And let me remind you, Mr. Witness, you are still under oath to tell the truth. Do you understand this? I see you nodding. Counsel, you have the floor. You will have 1 hour and 32 minutes left from the 2 hours and 10 minutes allocated to you.
Thank you very much, Your Honor. Good morning, Mr. Witness. How are you?
Good morning.
Just for the record, I will ask to go into private session, and I expect that to take about 25 minutes. So just that people have an indication how long that might take.
Madam Court Officer, can you please bring us into private session?
We're now in private session.
Thank you. Please proceed, Defense Counsel.
Thank you very much. Mr. Witness, we discussed yesterday the day that you were released. And that was the 18th, as you said. What I wanted to ask you is the following. You gave a statement to the prosecutor. And I'm on page 13 of that particular declaration that you made. Mr. Witness, you spoke about that you were kept in the barn where you were ultimately released from. And you said that about 7 or 8 days before your release, there was a gentleman who came into the barn, and I would like to quote that for you. And I'm on line 8. You said, "Sorry, I have mentioned too, I have forgotten to mention this. And I don't know, I have mentioned that there, that person, it was like this colleague of yours here. And he had some kind of bag. He looked like your colleague here, and he had some kind of bag. He was a good person, and he came and asked us how you are living here. Have you had food to eat?" And we told him what had happened, but we didn't tell him everything. Do you recall this, Mr. Witness, that you made that statement, to the prosecutor, speaking about this person?
Yes. Interpreters kindly ask the witness to sit closer to the microphone. Thank you.
Mr. Witness, would you please approach a little bit more the microphone so that everybody can clearly hear you? Thank you very much, Mr. Witness. So that person, what can you tell us about that person who came and who then asked, have you had any food to eat?
May I speak now?
Yes, you may.
At that time, this gentleman that came, he was a nice young man. He was thin. He had a bag. We didn't know who he was. We couldn't know, of course, because we were prisoners. But he came and he told the guards that were there, go out. And we understood that he was a good man, a just man. And he asked us, did they beat you? Did they maltreat you? Did they give you food? He asked about everything. We didn't dare tell him that we were beaten because, of course, we didn't know who that person was. We thought that maybe he was in disguise. But from that day, that person came there, and I hope God will help him. We were not beaten anymore, and they started to give us more food, but they stopped beating us.
Question for you. What is the background to do this specific question in a private session? Because what we have heard now from the witness and your question, in my view, could have been done also in public. And as I said yesterday, I really want to protect the confidential information in this courtroom. And at the same time, I don't want to make this a private trial. So I urge everyone to be so careful in what we choose to do in private or not. And even if we have to revert more often from private to public and back, I prefer to do that than to have these closed sessions, because we have a task to do, but it's a public task, and private sessions should be minimalized. And if we should not share any confidential information. If it happens, what it should not happen, we redact. But please, give it a thought and know that I don't mind if we are. We have said in our conduct of proceedings that or I think at one of our trial preparation conferences, that we think it's important that we group the questions in order to have private and to have private sessions and public sessions. But if it's difficult to do, then it's difficult, and then we will revert a little bit more. Okay? Please.
I understand, Your Honor. And I will ask to go into public session later on, but I think that we will have a lot of names, actually.
Okay, but this specific question, what was then the background to do it in private?
Microphone, please.
Another page, and there is names.
Okay.
Yeah, so.
Okay.
A little bit further in that same situation, you said about this person, there were other people, so we became 12 to 13 people there. From that day, that person, that gentleman came there. We stayed for another 7 to 8 days, and from that day, nobody beat us. We received no beatings anymore from that day. I don't know who that person was. If I was to see him today, I would just want to thank him. Is that correct, Mr. Witness, that you stated that?
Yes.
8 days when you were released. Is that correct? Yes.
Yes.
You were in that second barn, because this part is in the barn from which you were released. And you were in that barn not alone. You said we became 12 to 13 people. And I want to go back to the moment that you arrived for the first time in that second bar. Are you following me?
Your Honor, we're now in open session.
Okay, please proceed.
And did you have, during that second beating, also a bag over your head?
At the time that I was beaten, the sack was removed from my hands, and once I was standing, the sack was again placed over my head.
I understood that you said that during that second beating you also fainted a number of times, that you lost conscience. Is that correct?
Yes.
At that beating, were you able to see any of the perpetrators?
No, because it was nighttime, it was dark, and I couldn't see anyone. I was beaten up during the darkness.
So did you actually, for example, could see whether somebody had a beard or glasses on or something else?
Yes, I saw one who had a big beard.
Did anybody wear glasses that you know?
I think so, but I'm not sure. I have forgotten, because it's a long time ago when this happened.
Now, nobody, when you were being questioned by the prosecutor, he asked you whether any names were mentioned among themselves. And you said,
I do not remember.
I can refresh your mind in that perspective, and I'm reading from the transcript, page 31 of the very first day. And you said, during that beating of yours that you have described, did the perpetrators call each other by any names? And then your answer was no, they didn't.
Yeah.
No.
You mean that is correct? That indeed they did not call each other by names at that time?
Yeah.
No.
Excuse me, Mr. Van Bonet, I just want to make clear that I understand what the witness has just said, but I see also the prosecutor standing.
Your Honor, two very brief remarks, if I may. I don't want to interrupt. I hate to interrupt my learned colleague. Just two things. So if my learned colleague is making reference to the transcript, we'll be very pleased to see precisely which part of the transcript he's referring to. He said just yesterday or 2 days ago, but it was a 110-paged transcript. So we'll be very happy to be able to follow. So this is the first issue. The second one is that yesterday and also on Monday, the witness told us about 2 distinctive times during which he was beaten. And we would be very happy to know which beating precisely my learned colleague is referring to, because from the description of the situation, it seems that it's the first beating, but the question is what happened during that second beating. But the description of that, given by my learned colleague, suggests the first one, clearly. I'm making this intervention only because I would like to prevent the witness getting confused in the remainder of his cross-examination. Thank you, Your Honor.
Well, I read from page 31 of the
to give, and that is, Mr. Witness, did the perpetrators call each other by their names? Did they say names to each other? Did you hear my question?
Yeah, okay.
I do not understand. No.
The persons, did the, I don't want to use other words than used by the
perpetrators.
Perpetrators, that were the words you were using. Did they call each other by their names or by names?
Yeah.
No. Just once, in one occasion, I have heard one addressing another person that was a strange name, and the name was Tabut. And that's all I've heard. I haven't heard anything else later on.
Thank you very much, Your Honor. Are you with me, Mr. Prosecutor, regarding the transcript? I see you nodding. So, now, Mr. Witness, do you know if the person with the red hat that you have said, whether he actually participated in that beating in which at some point also a firearm was pointed to your head?
Yes.
And can you describe that person other than the person with the red hat?
I don't know how to describe him because it was night. And I don't know how to describe him.
You can't describe him. Okay.
I do not know how to.
Thank you very much. Mr. Witness, how do you in fact know that it was the accused who was among the perpetrators? The accused, my client.
Gavisha?
From the appearance? I do not understand the question.
Let me put it different. Do you know if the person who is standing here on trial was in fact among the perpetrators?
I do not know. I am not still understanding you, so no, I don't understand.
There is a person on trial in this case. That person is my client. And I'm asking you whether you know if my client, the accused, was among the people who were beating you.
Yes, it is for sure he was.
And how do you know that?
I know that because later on, I got to know that the main person was that person. I have never seen him again in my life. But when they put the torching light sometimes there, I saw that person. But I don't remember it exactly because it was dark. And logically speaking, there could not be any other person other than him to beat me, because he was the main person there. And everything he said was what was done in that place.
But you did not know that person ever before, correct?
Yeah.
No. So it's only there that I've seen him, and these 2 days in the courtroom.
And he never told you his name.
No, there has been no introduction.
So, once again, I ask you, how do you know that the accused is the person who was beating you? Because I just want to know how you know that. You didn't know the person by yourself. So could you explain me how you know that person then to be the accused?
Mr. Witness, please wait till the counsel stops talking, because the interpretation, if not, gets mixed up. Yeah.
Can I speak? Gentlemen, so that person that you are mentioning 100 different times to me, there is no reason for you to mention him that frequently, to tell you the truth. And I have told you that I have not known the man. I didn't know anything about him, what the problem was, and at the end I was not a fool. So I knew where he was. The person that you defend is this person, so that's the person. And please don't ask any other questions of this nature, because it seems like irrelevant to me.
Well, Mr. Witness.
Defense counsel, I just want to address the witness. Mr. Witness, the defense counsel is here to ask questions to you, and these are relevant questions for the defense. So they must be posed to you. Yeah. And you answer as you deem proper, but they have to be asked to you if the defense lawyer wants to do that.
So I ask you again, how do you know it was the accused that was beating you?
I think I told you how I know. I told you.
How you know the accused, being the person that was beating you?
I know because when I left the prison, I knew it, I got to know it, who the main person was at that place over there. And the only person that can be, it's only him. There can't be another person, it's only him.
So you didn't know at the time yourself, but you heard it from others. Is that what you are saying?
Yes.
Did you hear that? From who?
It's not of importance to tell you on who did I hear it from, so there were too many people.
Of importance, Mr. Witness, and I want you to answer that question too. Who said to you?
I do not remember, so I'm not here to give the names of other persons. I'm here to give a testimony on behalf of myself, but not mention other names.
But I want to go in private session then, Your Honor.
And then you will give an explanation for the reason when we are in private session. Madam Court Officer, let us go into private session, please.
Your Honor, we're in private session.
Thank you, Madam Court Officer. Defense Counsel, could you...
Mr. Witness?
No, I'm directing to you.
Oh, sorry.
No, sorry, I was not clear. Could you give an explanation why you want to go into private session?
Well, maybe the witness will feel more comfortable to name names if indeed we are in private session, and maybe that would be the reason why he's not giving the names. So I just want to make sure that the witness is completely comfortable.
Okay, but it's
in
important that
expressing
you...
himself.
Okay, thank you for your
Yeah,
explanation.
so-
I will be asking to the parties and the Victims' Counsel when we go into private session to explain it to me, so it's not only
Okay.
to you,
Yeah.
because I realize that it will help me in thinking through if we do it or not, because I really want the public to participate by watching this trial. So please proceed.
So, Mr. Witness, we are in private session. It means nobody can hear you outside this courtroom. Do you understand that?
Yes.
Asking you again, Mr. Witness, can you tell us the names of the people who told you that it is the accused who is the one who was beating you or who was the main person there? Who are those people that told you that?
I cannot tell a single person to you because there is no need for me to tell anyone to you.
Mr. Witness, is it actually true whether people actually told you
talking to you, you are under oath, yeah, and you to tell the truth, and you should not withhold information. If you have forgotten, you say, I have forgotten. But if you have relevant information at your disposition, you should share. So I give now the floor back to the Defense Counsel.
Mr. Witness, I repeat my question to you. Who told you that it was the accused who was the main person there and that participated in the beatings of you? Who told you that?
Nobody.
I do not know. I do not remember.
Mr. Witness, at what occasion was it that the people that you do not remember told you that? At what occasion was that?
When the war finished, when it was over, I spent time with all different types of persons. I spent time with my fellow villagers. And I got convinced 100% that this was the person that was the main person there in Slush.
My question is, on what kind of occasion was it that you spoke to somebody? Was it in your house, or was it at a person's house, or was it in a bar, or what was it? Where was that it was told to you? If any of the people that you spoke to had ever any contact with the accused, my client?
Nobody.
I do not know.
Of none of the people that you spoke to?
Yeah.
None.
Counsel?
Yes.
I just reread the answer of the witness. You have asked him of none of the people that you spoke to, but I see that he has answered, I do not know if any of the people that you spoke to ever have any contact with the accused. And his answer is, I do not know. So, yes, but none. I don't. He was just repeating what you've said, but I think that the answer is already before that. Okay, so let us not confuse the witness with a question like that.
You say you have discussed it in your family. Did anybody of your family ever meet the accused?
Yeah.
No.
Did anybody of your friends or whoever you went to when you discussed that ever met the accused?
Yeah.
No.
Defense counsel, I would like to go into public, if that is okay for you.
Okay.
Madam Court Officer, can we go back into public?
Your Honors, we're back in open session.
Thank you very much. Mr. Van Bonnet, you have the floor.
So you heard of other people that told you that you don't want to tell their names, or you don't know their names anymore. You don't know whether they had any contact with them. So it could have been completely somebody else who did that to you.
Yeah.
No.
Say yeah.
No. Just can't be.
Prosecutor, kita bisa.
Sir, do you have any other questions? You're keeping me the whole day here on one single question.
And I want you to answer that question. Why could it not be anybody else?
I'm answering your question. I'm telling you that I don't know, and then you keep asking me again.
Well, you did not say I don't know. I just said why not, why can it not be somebody else? And now you say I don't.
Defense counsel, I see I see the SPO and the victims counsel standing up, but the judges also want to go back to discuss a matter. So I will first give you the floor to both of you, and then anyhow we will go back into deliberation. Prosecutor, Mr. Prosecutor, please, you have the floor.
Yes, thank you very much. Just a very brief point. The witness has been asked several times the same question, and he gave 2 or 3 times the same coherent answer, and I think we should not waste time and just move on. Thank you.
I heard your observation. Victims counsel, please.
Thank you. Yes, indeed, it's Rule 143 I am looking at, and I don't see that either any further questions would help us in ascertaining the truth any further, and avoidance of repetition is a key point here, and we are, in my view, not with spending any more time, will be able to shed further light on this. Thank you. So I would object to any further questions along this line.
Yes. Thank you.
Your Honor, may I briefly?
Yes, of course, of course.
Well, the witness sometimes simply refuses to answer, or says, I cannot tell, well, that is an answer, or I don't know, that is an answer. But simply saying that I do not want to say any other names clearly indicates that he knows names and he doesn't want to share that. We do that in public session, we do it in private session, any kind of session that he might feel comfortable in, but I think it is important when we in this court are trying to determine the truth of what happens, that indeed also difficult questions have to be answered by a witness. And a witness is here under oath, and he must answer questions. And if he's unwilling to answer a question, then we need to have measures that he will ultimately answer the questions. And it's not at the random of the witness that we are going to have, oh, I'm just not willing to tell you, or I'm not going to tell you. It is clear that he indicated that, and that is why I'm persistent and insisting on it. And I think that is the right of the defense. It is also in order to establish the truth and whether a witness actually speaks the truth or not. That is what is to be determined.
Your point, thank you for your observation. I see the Victims' Council standing, and indeed it's better to stand up than to raise the hand. Then it's clear for me what's happening. But yes, please, you have the floor.
Yes, thank you, Your Honours. As a quick response to my learned colleague here, I do not think that it accurately reflects of what we have heard so far in this court, that we have a witness who doesn't try, who simply refuses. He has offered explanations of why it is so difficult for him to provide us with any further information. We are looking back at a situation 22 years ago. He has described how he has spoken to a multitude of different people in a situation in which nothing was normal. Recall that this was, as he was saying himself, a situation in which they were in the upheaval of war. It wasn't returning back to normal. And therefore, I do not, or I object to any suggestions on the part of the Defense Counsel that this victim doesn't try, this witness doesn't try his best to provide us with the knowledge that is still present. Thank you.
Your Honor, if I may, the witness already on the first day said to the prosecutor, I just know it for a fact. And then the prosecutor just took that as an answer. He did not go on to it. How do you in fact know something? How can we in fact establish the truth about some particular fact, whether it is a fact or whether that is in fact not a fact? Whether it is a belief of a witness or whether he takes it as a fact from somebody else, rather than that saying, I know it as a fact. When somebody says, I know it as a fact, then I think it is important to establish how that fact is established by a witness. That is nothing, and that is exactly what it is all about in a criminal case, rather than saying, as the prosecutor did, well, you know, I appreciate the answer, but I would like to state something further than that, and he keeps it like that. I want to insist on this point because I think it is very relevant for a case when somebody, an accused, is being accused, in fact, by a witness, that he says it is him, and he has no reasonable explanation of how he was able to establish that. Thank you. And I think that is what a criminal trial should be about, rather than continuously saying, oh, you know, it's a long time ago, and so on. We all know that.
Mr. Defense Counsel, no, and I interrupt you. For the next time, if we have this discussion, I will ask the witness to take the headphones off. But for now, I'm going to go back. I see your point, defense counsel. I've also heard the SPO and the victims counsel. And to tell you the truth, for me, the question put to the witness, so it could have been completely somebody else who did that to you. For me, it did not follow logically from what you were saying before. So you can ask questions, of course, to the witness on what happened then, who he saw, and who he says that has been beating him or ordering to beat him or being in command there. But for me, I was going to stop you when you said, so it could have been completely somebody else who did that to you. I didn't see the logic coming from what you said before. So we should be careful to phrase it like that.
Because, Your Honor, it can be the personal conviction of somebody that it is something like that. It can be somebody's, or that somebody takes it as a fact, rather than it being a fact.
No. Mr. Witness, can you take your headphones off? Yes, but I do tell you, I see your point, I'm listening, and you will be able to pose the questions you deem necessary. But what I'm seeing that the witness has given an explanation, and if you have other questions on the same topic, I will allow them to you, because it's necessary, but not to ask the same question if he has given an explanation how he heard it. That's what he has given that explanation. So if you want to verify in another way his knowledge, and I've seen that you have been going through persons he talked to, his family, I see all that, but not repeating it, because except that the fact that the witness doesn't want to answer the question is not a reason not to answer. He's here to answer. But I kindly ask you to refrain from repeating what he has already tried to explain. But if there are other questions, and now I'm repeating myself, you can ask them. But asking 4 times, that will only make him nervous, but I don't think it will bring him to a point that he will share with us information. So you have the floor again, and I was going to deliberate with the colleagues, but that we will do that in another moment. Please continue. Mr. Witness, we will continue now with the interrogation, and the floor is for the defense counsel.
Mr. Witness, did you ever verify for yourself the information that you received from others regarding the accused?
Yes. The army, all of them who were in Slush, know that this person was the main person there. It's not only one person who knows this. Everybody knows, and you know even better than I know who the main person was. I'm just saying here that I'm here to answer questions that relate to my circumstances. Who beat me? Who did these things to me?
I understand that, but I was asking you how you verified, in fact, whether the people that told you something, whether they were right or wrong about something. How you verify that?
I don't know how I can answer this question in a different way. I already gave you my answer.
Okay. You never met the accused anymore in your life. If I put to you that the accused says that he has never ever met you in your life, in his life, what is your reaction?
I wouldn't know whether he met me or I met him. I never saw him in my life again, and I was not interested in him at all.
And what would be your reaction if I tell you that my client says that he has never ever been beating you in slash?
Then it's you who beat me in slash. Who else?
Mr. Witness, it is not the place here to make jokes, and certainly not to say something like that to the defense counsel. Yeah? Do we understand each other?
May I speak?
But have you understood me that you cannot say that to the defense counsel?
Yes, yes.
I had the next question, actually. My question was answered.
Excuse me?
I had a next question, but...
Yes, but I don't want the witness to say this kind of things. You have the floor.
Mr. Witness, I put it to you that my client tells me that he has never ever beaten you in slash or anywhere else. What is your reaction?
He can say whatever he wants. That's his business. I cannot tell him what to say. That's his job.
Mr. Witness, you said to the prosecutor upon his question that it was about a month after the war that you heard from others.
Mr. Van Bonnet, could you tell us where you saw that in the script, in the transcript?
Oh.
That's a request. Okay.
That is
but it's important that we have...
I can...
okay, but then I look at the...
Tell you it was about...
No, you cannot retry. You don't have the reference.
Just a minute.
Yes.
We're looking into it.
Mr. Van Bonnet, I don't want to keep it too much. You can give the reference afterwards for the use of the parties, the other party and the Victims' Counsel and the panel.
Yes? I will, Your Honor.
Thank you, thank you.
Okay. Page 45, I hear. Can Can I see that? Line 22, excuse me. If we look it up, it's on the screen, page 46. The number under it is page 45, and it's line 22.
Thank you very much.
That is where it is. Mr. Witness, upon a question of the prosecutor, you answered that you learned about a month after the date of your release about that. Do you recall where that was when you heard that for the first time? Do you?
Your Honor, we're in private session now.
Thank you, Madam Court Officer. Defense Counsel, you may proceed.
I believe my question was, Your Honor, whether he asked his wife if she had verified that, and then it was how she had done that. And then we are about to receive the answer.
Mr. Witness, please proceed.
I don't know.
Best time to take a break, Your Honor. I would go into another topic, and I think this topic has been covered. So I think this is maybe the natural moment to have a break, and then afterwards we continue with some other questions.
Okay. Thank you.
I'm not sure what time I still have left.
No, it's one. We have 3 minutes to go, so it's perfect timing. Thank you for that. Madam Court Officer, can we go back into public session?
Your Honors, we are back in public session.
Thank you, Madam Court Officer. So it's now time for the first break. I see, Defense Counsel, that you have used 1 minute and 1 hour, 42 minutes and 65 seconds up till now from the time allocated to you. Mr. Witness, we are now having a break. I will ask the court usher to accompany you out of the courtroom, and we will see each other again in 30 minutes. I adjourn the hearing.
All rise. All right.
Please be seated. Good. Welcome back. Before we usher the witness into the courtroom, Mr. Van Bonnet, I shared with you how much time you still had. It's about half an hour, but the panel wants to inform you that if you need more time, you can ask, of course, the panel. It's not the grocery store waiting the strawberries, so. Okay. Yes. Let us start. Court usher, could you please bring the witness back? Thank you. The witness comes in. I would like to call appearances. I'm looking at my right-hand side to see that the same persons are present. Thank you. For the victim's counsel, the same. The defense counsel, the same. Mr. Mustafa, I see that you are there too. Good. And then I see that the registry is not there anymore. So, for the record, and the trial panel, of course, is there too. Good. Mr. Witness, welcome back. I didn't hear translation of what Mr. Witness said. Is it working properly? Because I heard the witness say something, but I didn't hear translation. What did you say, Mr.
The interpreter didn't hear what the witness said.
What did you say?
I'm dead.
Thank you.
Yes. We will resume with the posing questions by the defense counsel. Mr. Van Bonnet, you have the floor.
Thank you very much, Your Honor. Thank you very much, Mr. Witness. Here we go again. I will go briefly in open session. Sorry, no. I will be now in open session. Then I go briefly in a closed session to just explain something to the witness, and then we can go into open session as I will be referring to something.
Okay. In private session, you mean?
Yeah. Excuse me. Yes.
Yeah.
Sorry.
Okay. Good.
Mr. Witness, you were released from the location where you had been detained. And
The sound in my headset is low.
is it better? Yes?
Yes, thank you.
Witness, you were released from the place where you had been detained at some point, and that is what I would like to discuss with you. At the moment that you were released, do you recall when you came outside, actually? Could you share with us what you then actually saw?
Yes, on the 18th. And I know of the date after I was released from prison because I didn't know what the date was, or what the night was, what the month was. It was about 11 o'clock, I think, when the door was opened and we were released.
And when you were actually, the door went open, I think you said earlier that you were one of the last ones to leave that particular room. Where did you come into? Where did you go and where did you come into? Can you describe that for us?
I left. We were called by our names. Like I said, there were two people left behind. When I got in the yard from the barn I was into, I saw many people because it was the offensive, and people were leaving, and everyone was looking after their own hands.
That you saw, approximately.
I saw all different sorts of people. I saw people in civilian clothing. I saw people in military uniforms. There were a lot of people there.
And can you give an estimate of the amount of people that you saw? It's obviously that anything that it is approximately.
In the yard, I didn't have the time, I didn't have the need to, but I would say that there were at least 60 people there.
And Mr. Witness, did you see any other buildings there actually, or not?
I didn't even look for that. I don't know whether there were any or not.
And these people, were they just standing there, or what were they doing there?
Yes, they had come from all over the place. They had gathered there, and they sent us a person. One person told us where the road was so that we could go to Pristina. He pointed the road at us so that we could go to Pristina.
And what was the weather like? Do you recall that? Whether it was cold or was it clear sky? What in your... How do you remember that?
It was an average weather. It was not cold, it was normal weather.
And did you have any idea whether there were any other buildings than the building in which you had been detained?
Yes, yes, there were others.
Would it be possible for you to describe what you saw as far as buildings is concerned, structures or?
Well, there were the buildings where I stood. I don't know how many buildings there were. I was not interested to see them. But while I was released from there, I was just interested to know where I was heading for. So they pointed the road to us towards Pristina, and I was lost and I didn't even know what direction to take. But I followed all the other people. So I followed many other people.
Just, I want to remain a little bit at that moment that you are released and you look around, you see people, but I'm interested in whether you see any other buildings around you, other than the building from which you were released.
I have seen, I don't know whether there were one or two or three, they were not very far away from where I was. So there were about, I don't know, probably 50, 60 meters away.
And did you walk on a level field, or were you going uphill, or were you going downhill? Could you explain that to us?
No, where I was, starting from the building I was kept, it was kind of a path. It was not a good road, a good path. It was usually, I mean, it was mainly a meadow. So then we went towards another road, which was of a better quality, and it was that road that took us to Pristina.
Your Honor, we're now in private session.
Thank you, Madam Court Officer. Mr. Defense Counsel, you have the floor.
Thank you very much.
Your Honors, we're back in open session.
Thank you, Madam Court Officer. You have the floor.
Mr. Witness, can you first tell us, because when you were released, you went to Pristina, and could you tell us which road you went to, which villages you passed through to get to Pristina? So you went all along the road.
Yes. Well, I started the journey from the place I was. And then I went through a village. I can't remember the name now. The village is called Servadict.
Okay.
Then I went through another village that is called Ubriali. There, the main road that connects that village to Pristina is located. Afterwards, the village of Makovs follows, and it heads towards Pristina. When I was in that road, there were thousands and thousands of refugees that were heading towards Pristina.
And then I would like now to go into private session.
Madam Court Officer, can we go into private session, please?
Your Honors, we're back in public session.
Thank you. Defense counsel, you have the floor.
Mr. Witness, we have some last questions. You are asking for compensation, to get some kind of compensation. Did you ever ask anywhere else to get compensation for the injuries that you had suffered?
No, because I don't know of any other court besides this court.
I mean, there is legal possibilities in Kosovo too, so why did you not seek any possibility to do that?
Yes, okay. So,
I wasn't interested. I cannot ask for compensation in 100 different places. There is one place.
And that place would be maybe Kosovo. So why would it not be a good option for you to ask for compensation in Kosovo during all these years?
To tell you the truth, I didn't look for a place because I wasn't aware. I didn't know.
And could you not seek any help in order to find that in Kosovo?
No, never. I wasn't interested.
And why are you suddenly now interested in it then? Because here you ask for compensation. So what could you explain? Why are you suddenly now interested in that?
Because I do need compensation.
And how much compensation are you seeking, actually?
As I said, I don't know to what I'm entitled. I just want to get what I'm entitled to. I'm not a judge here, as I said.
Oh, Mr. Defense Counsel, please. I see the Victims' Counsel standing.
Yes. Thank you very much. Could I perhaps remind the defense that it's the ascertainment of the truth that should be the focus of your questions? Questions on why someone seeks to exercise a human right, and the right to reparations is among those, is, in my view, beyond the point here. Also, assessments as to what kind of compensation at possible amounts is something that the witness won't possibly be able to ask. The court itself issued seeking expert advice of 3 different experts on questions linked to reparations, and therefore asking here this specific witness on something that he cannot possibly give an appropriate answer to is therefore, in my view, objectionable.
Thank you. Mr. Defense Counsel, you have put your question, and Mr. Witness has given an answer to that. I would not...
I had one final question on it. It's not
you
about
can,
amounts or anything.
You can say it, and then we will see if you can proceed.
You know, in which manner do you expect any compensation?
Defense Counsel, where are you going to with this question?
Just want to know what is the expectation around, as far as compensation is concerned, of the witness? Is he seeking for compensation?
But are you asking him what is compensation for him? Is that what you are asking?
In which manner, whether it's in funds or whether it's in any other manner that can contribute to compensate injuries or anything that could help him, benefit him in any kind of manner. So rather than focusing on whether it is money-wise or any other kind of thing, what are the expectations of this gentleman?
Okay, but because the question needed for me some explanation too.
Yeah.
So I would say you might want to explain some more what you're trying to ask. Yeah, I saw it. And I saw in the corner of my eye that you were standing. So please, you have the floor.
Yes, just briefly to revert to Rule 143, where we are under paragraph 3, having a clear provision that the cross-examination shall be limited to the subject matter of the direct examination and matters affecting the credibility of the witness. I cannot see how any questions on what kind of reparations, which is actually a question that is very difficult even to answer for legal experts themselves, given that reparations are still something in the development of the law, how this can therefore, under the rule I just cited, contribute here.
Your Honor.
No, wait. At this point, I will also give the floor to the SPO, because now we have a real point that we should decide on. Please, Mr. Prosecutor.
Your Honors, this is the cross-examination of, by the defense counsel of the witness of the opposing party, and we believe that the counsel should be allowed to explore all the matters that he believes could go into the credibility of the witness. So maybe Mr. Van Bonnet could be given a chance to explain why his question goes into the credibility issue, and if he convinces the panel that those questions indeed go into the heart of the credibility of this witness or any matters that he was testifying about before, he should be allowed those questions, because it's a question of his cross-examination leeway given by the panel. And I think we are in the discussion of what is allowed, what is not allowed. It will also impact later on the prosecution powers to cross-examine and the extent to which prosecution could cross-examine the witnesses.
Mr. Prosecutor, excuse me, I want to say something to the witness. Mr. Witness? Could you take your headphones off? Thank you. Please, sorry that I interrupted you, but I think this was better.
Your Honor, so what I have just said stands. We believe that if these questions go into the credibility of this witness, they should be allowed to ask. However, perhaps Mr. Van Bonnet could explain a little bit more why these questions are indeed relevant. They might be relevant, so maybe let's give him an opportunity to explain. And as I said before, we have to have a level playing field in this regard, because later on the prosecution might be in a similar position, talking about the credibility of the witness of the defense. So maybe it's good to have a clear line on this. But perhaps Mr. von Bonnet could clarify this a bit further.
Yes, I will continue to make rounds then in order to have everybody say its view on this. I saw a movement also at the right side again, but you are fine with the comments you made. Mr. von Bonnet.
Yes, I can explain.
Yes, as with regard to the credibility, would you like to comment on that?
Well, there is, let me first address the issues that I want to explain to you about this. The SPO obviously asks about the health of the person and what kind of injuries he suffered, and obviously a part of that is also that he's seeking compensation, and these issues will be at some point also be addressed at some point in the proceedings by the defense. And without being able to pose any kind of question to the witness, and it has nothing to do about the fact whether I need to know how much or what, just, you know, what is in fact the compensation that he might be looking for, and for what in particular, if that is the head injuries or mental aspects. And as I said, I earlier explored why that he not did that in Kosovo itself. Now, as to the credibility, I mean, the credibility, of course, also is about the fact if somebody seeks compensation for anything, then that I mean, let me put it like this: I will test it lightly, whether that is in effect related to any of the issues that we are dealing with in the course of the defense. And in that perspective, I think that it can be a part of his credibility on that issue. Yeah. We cannot just have a case in which we say, well, okay, these are the medical records of somebody, this is what he suffered, and then afterwards we would not be able to ask any kind of question about that. And that relates also to the issue of the compensation, without being a prime topic, but it's just something that I want to cover. And equally, I mean, people are fine with defense witnesses or whatever to do the same.
Okay, you know? Thank you. I think there's a question here with regard to the witness. The witness will be excused for a moment. I would like to ask, I will give you the floor, but I would also like to ask the SPO to comment on the point raised by the defense counsel. That's not only about the credibility that questions should be posed, but also in general about, if I summarize you well, Mr. von Bonnet, about compensation as such, because it is an issue in, it could be an issue in these proceedings. So I will first give the floor to the specialist prosecutor, and then I will come to you, and then you can also comment on that.
Your Honors, thank you very much. We have two issues here. First is the credibility issue, and we believe that also according to the rules and according to the practice of most courts and many tribunals around the world, in cross-examination, I'm talking about systems who allow cross-examination, of course, more leeway should be given to explore credibility. The rules also talk about the cross-examination, that one of the purposes of cross-examination is indeed to challenge or attack even credibility of the witnesses of the opposing party. So this is one thing. The second issue is cross-examination in general as a process. So, of course, it varies from jurisdiction to jurisdiction. In many jurisdictions who prefer the adversarial model, cross-examination is much more robust, and judges usually give the cross-examining party more leeway to ask some more questions, because they should be, the counsel should be given leeway, more possibilities to effectively challenge the witness and the story of that witness. It's not only about credibility, it's about inconsistencies, other issues. I'm saying all that in the broader context, as I mentioned before when I was given the floor. At some point, there will be a moment when also the prosecution will be posing questions to the witnesses put forward by the defense. And I think it's a discussion we should probably have with regard to how much leeway should be given in cross-examination, and whether, for example, leading questions are allowed or not. In some jurisdictions, indeed, in cross-examination, leading questions are allowed. In some, it can be only open-ended questions. So, as we are having this situation for the first time, maybe you should give it a little bit of more consideration. The panel, maybe all of us could contribute to the discussion, maybe on paper, maybe during the next session when we also internally, and also the defense, discuss this issue. And we can come back before Your Honours with some more comprehensive position on this. Cross-examination in general, this is my point. What is the scope of it? What is the allowed scope of it?
Thank you for your comments, observations.
Thank you, Your Honours.
Victims' Counsel, you have the floor.
Thank you very much. Yes, we've got to distinguish two different things here. The one is the criminal trial in which we have the task to establish specific facts that happened. And for that, this witness sits here and has to testify and has to explain his recollection of his experiences and those facts that he can recall. And this is what we need to test in this cross-examination, or what the different parties need to test. The question of the legal consequences is a different one. And there can be different legal consequences to the facts that we, at the end of this trial, might have established, and that you, Your Honours, of course, are called to establish. Those legal consequences can be a conviction. In that case, would we ever ask a witness here, how long do you expect the accused to go to jail for? Not exactly a question that to me occurs as one that the defense might want to pose, or anyone else, and not one where we would think this actually helps us in ascertaining the truth. And the same is true, in my view, for what kind of compensation does someone expect? Because it is the question of reparations as another legal consequence that may flow from, depending on the facts that have been established. And this is what we are doing here at the moment. And this second question on the legal consequences with regard to reparations is one where we, and as lawyers, I'm sure we all are capable of doing so, need to think basically along two different tracks that run alongside, and that is ultimately this reparations claim, which is of a different nature. And we are in uncharted territories here, because it is the first case before the KSC, and because different courts before us have done it slightly differently. ICC, for example, therefore separates out the reparations proceedings as such. While we don't do that, this doesn't mean that this would be the appropriate point to discuss with someone who hasn't had the chance yet to have the full legal consultation on this matter, and could have had the full legal advice. And we're actually getting to a point here where we might need redactions, because it might occur that the witness is someone who may be among those participating. Yeah. So this is something to think about, and I try to speak more in the abstract. So every victim participating in the proceedings who may seek reparations, and we've made clear that this is the case, can only over time fully understand the nature of this and the possibilities. For example, for that, all the expert reports that have been asked for still need to be heard, and only then can ultimate legal advice be given which would inform the victims participating to form their opinions, and only then do we actually have a sort of a solid ground on which we can stand. This would be absolutely premature to discuss here at this point with this particular witness. And therefore, I think this is under no circumstances anything that where the cross-examination is the right place for this. Thanks.
I would like to ask the floor for one issue about this again, but I think it is better to do that in private session.
Defense counsel, for the next time, I was going to refer to you. I will not forget you. We have all our parties and the victims counsel here, so I will give you the floor now. Please, Madam Court Officer, can you bring us into private session? Thank you. Please, Mr. Prosecutor.
Thank you. If I might, thank you. I'm sorry to interject, but since this implicates an office policy, I'd like to just address it briefly. I just want to be clear that we have some difference with the Victims' Council on this point. Our view is that there is room to explore credibility issues with respect to issues of compensation or benefits. However, I think that it would benefit the process and the fairness of the proceedings if they were done with some directness and specificity. That is, if the questions were put to the witness, if it were directly put to the witness, if his motivation is affected by the compensation, if that's the reason he is here. Dancing around the compensation issue I don't think is particularly fair to the witness, and it raises these questions about whether we're really in credibility or motivation. Our position is that there's room for these questions. However, they should be asked directly and pertinently, and the witness should have an opportunity to address whether, in fact, his motivation, he is motivated and he is here testifying in this courtroom about these charges, and in this case, because he expects to receive compensation. So that's the position of our office. Thank you.
Thank you, Deputy Specialist Prosecutor. Good. Are all views being brought sufficiently before the panel? Yes? Now, what the panel will do, we will go back, we will have a short deliberation just to see where we stand on this, and then we will come back. And I don't think it will take us very long. So,
All right.
the court is adjourned for 5 minutes. For the translators, the court is adjourned for 5 minutes.
All rise.
Madam Court Officer, could we please go back into public session?
Your Honors, we're back in open session.
Thank you, Madam Court Officer. I have a look at the time, and I have an answer to the specific question you want to pose, but we have decided to give some more general guidance. Will not be, I don't think it will be an oral order, but some general guidance after the break on this issue. We already said in our conduct of proceedings that we were not going to issue a decision on specific questions, but as the matter has been raised now, we can give some guidance on that. The witness is already outside. We will leave him there till after the break. There is a question for the defense counsel with regard to his client. Has the connection been for so far good? Yes, and that went fine. No. And Mr. Mustafa, I did not say this morning, but I will say it now to you. You have the right to remain silent, and no consideration will be made in the determination of your innocence or guilt. That I have to say always to you before I talk to you. Can I ask you if the connection has been fine?
Oh.
Yes, Your Honor. Very good.
Sorry, Madam Interpreter, could you repeat what the accused said, because I was without my headphones?
Yes, Your Honor. Very good.
Mr. Mustafa, was the connection fine? Could you follow the proceedings well?
Yes, Your Honor.
Able to consult with your lawyer?
Yes, Your Honor.
Just to assure ourselves that you can effectively follow these proceedings and participate. Good. Now, then it's now 1 o'clock. We break till 2:30. The hearing is adjourned.
All rise. All rise.
Please be seated. Okay, welcome back, everyone. First, I have a general remark. I would like to ask the parties and the Victims' Council that when discussing, you direct to me and not to each other. I think that will be a good thing to do. And then I promised to give some guidance with regard to the types of admissible questions to put to the witness when it comes to compensation issues. Okay, without schooling you, but there are two procedures ongoing before this panel. On the one hand, we have the criminal proceedings regarding the establishment of the truth within the confines of the confirmed indictment. And on the other hand, we have the reparation proceedings in case a conviction is entered on and the panel does not decide to refer the victims to the Kosovo courts. And I refer to filing 124, paragraphs 14 and 15. In cross-examination, the defense counsel can in principle ask questions regarding both proceedings. According to Rule 143, paragraph 3 of the rules, in cross-examination, questions as to the credibility of the witness can be asked, including by exploring the witness' reasons for giving testimony. It is not allowed to ask the witness why he or she wants compensation. Witnesses who are also victims participating in the proceedings are entitled to compensation under the legal framework of the KSC if they meet the conditions. The witness can be asked about the motives or motivations behind their testimony to the extent that these may affect their credibility. Furthermore, it's important to keep in mind that the purpose of the questions put to the witnesses should be to establish the facts. Admissible questions include, for example, the kind of harm that the witness has allegedly suffered as a consequence of the crimes charged in the confirmed indictment, the medical cost incurred, the nexus between that harm and the alleged facts in the confirmed indictment. No questions to the witnesses are allowed that aim at eliciting his or her views on the type or amount of compensation that he or she wants to receive. Scope and modalities of the reparations, if any, shall only be discussed at a later stage. So, then with regard to your question, Defense Counsel, you were saying, what kind of compensation do you seek? Right? Those are my words, the Defense Counsel. But is that was that what you asked for?
Yes, Your Honor. So not why.
So not why, but what. So
what?
This question we will not allow.
Okay.
You have some more questions for the witness? The microphone.
Yes.
Okay, then. Yes. Good. Before I let the witness in, I will call appearances. I look at my right-hand side, and I see the same faces.
No changes, Your Honor, in the composition.
And the Victims' Counsel, the same. Defense Counsel, you are the same team. And I see Mr. Mustafa, who is present. And I see the representative for the registry. Okay, so, and the panel is there too in its completeness like this morning. Now, Court Usher, could you please usher the witness in again? Thank you. Mr. Witness, welcome.
Hello.
Continue now with examination by the defense counsel. The defense counsel, could you indicate how much time you think you will be needing still?
I think not more than 10 minutes.
Thank you. You have the floor.
Good afternoon, Mr. Witness.
Good afternoon. And tell the doctor that I was beaten up by the KLA. I said I was sick, and I told the doctor that I don't know what I'm sick of.
And for what reason were you ashamed? Did you know that doctor, or was there any particular reason to be ashamed?
So I'm ashamed to mention it even here, let alone to mention that before the doctor. It's not good to beat somebody up. And for that reason, I didn't tell him.
It's not good to beat somebody up, but at the same time, it's also not good to tell something that is not the truth.
Where's the question?
Would you agree with that?
Myself? No.
Defense counsel, I don't think the
I understand.
victim has understood your question.
It is not good. It is not good to lie to your doctor. Would you agree with that?
Yes.
And once again, could you explain why you, as a person who was a victim of beating, would need to be ashamed to a doctor of a hospital?
I don't know, probably I'm stupid, but I was afraid, and this is what I said. So when I went to the doctor, he had the surgery upon me, and he knows why and what. So it came from something, but that is what it is.
And did you ever go back to that doctor?
Yes.
Later on, what had happened?
No, man, I didn't. He did his job. He asked me what the cause of that, and I told him I don't know. So he had the operation on me, and he knows that I don't know anything.
Defense counsel, I see the specialist prosecutor standing, please.
Your Honor, I hate to interrupt, but as this is a public session, as we understand, yesterday we were asked by Madam Court Officer to switch off the microphone after posing each and every question, so perhaps also my learned colleague could do the same. It's the security issue of the witness. That's why I'm intervening.
Thank you, prosecutor, for making us notice that.
In the next document, which reads 104, it's the following page of the same set of documents. It's a discharge list. So that is SI is 061012 until 061015. Now, let me see what would be the tab. Most probably
Defense Counsel, I was informed by Madam Court Officer that if we are in public session but not showing the document in public, not showing the document, then Mr. Mustafa will not be able to see the document. Okay, in both sessions you will not see it. Okay. Good. It doesn't. We were searching for a way to have your clients seen the document too, but that is not possible. Do you agree with that?
Yes, I agree with that, Your Honor.
Okay.
I think the tab is most probably tab 11 of the prosecution. Yeah, just are we now in private session or are we in public session? Okay.
Microphone, please.
We are in public session, but for the public, this document is not visible.
So, do we see the document?
Yes.
Oh, yes. All right. Yes. Mr. Witness, can you see this document? Yes.
Yes.
Mr. Witness, on the right bottom corner, could you please say what is written there? In the right bottom corner.
It says the KLA.
And on the left side,
On the left side, it writes the military police.
Right. Could you please indicate why the word UCK is written on the right side and the military police is written on the left side of that document?
How to write it otherwise? I don't know how.
No, I don't think we understand each other, Mr. Witness. I will explain better to you. In between, there is also something written above a horizontal line. Can you see that?
Yes. It reads, so it says about 1 kilometer, the military police was away from the army of Kosovo.
Much. And on the top right, I believe there is also written a name. Is that correct? Above the circle, on the right side of this document. What is that name?
So the name is Fatmir Sopa. He is the commander of the KLA.
And why did you write down his name there?
I was asked who was the commander there and who was the commander here. So now I don't know why I have said that name, why I've written that down.
There seem to be on this sketch two parts, the UCK and the military police.
Yes.
With this sketch and the 1 kilometer, what did you try to indicate?
I was asked what was the distance, just like you are asking me now, and I indicated on this drawing that the distance was 1 kilometer approximately.
The police and the army, UCK.
Yes.
And was Fatmir Sopi the head of the UCK, the army there?
Yes.
His house?
No, never.
And do you know who was the head of the military police?
Yes, that was your client.
That is what you were trying to explain in this sketch. I understand. Okay, I have no question on anything else on this document. Let me just briefly check. How did you actually get to know that the distance between the army and the military police was 1 kilometer? How did you get that information?
I knew approximately the distance. I'm not a geologist to measure distances.
your detention?
Sir, how could I know such things in war? These questions that you're asking me about distances and everything, when once, and not just once, I mentioned here that I was kept inside. I stayed all that time in the barn.
So how could you make this sketch then? If you didn't know, and if you couldn't know, how could you make this sketch?
I'm telling you, sir, that was what I thought the distance was. I didn't measure it. I'm not an expert. It was just my assumption that that was the distance.
Your Honor, I think we have finished. I thank the court and I thank the witness for this moment.
Pursuant to Rule 127, paragraph 3 of the rules and our decision on the conduct of proceedings, the panel may allow a redirect examination as deemed necessary. Mr. Prosecutor, do you wish to proceed with the redirect examination of the witness? And if so, how much time do you think you will need?
Your Honors, I would be indeed willing to proceed with redirect examination. We are going to explore just two issues that could still raise doubts, perhaps. We've got to just clarify those. And I envisage that the total time that we would need for that would be around 15 minutes. I hope not more than that.
Okay. Thank you for that information. I will try for today, and I am informing you of that, I already asked CMU to add one extra session of an hour for this afternoon in order to see that we finish the examination of the witness today. That would be what I hope to be able to do. Yeah. So, good. Mr. Prosecutor, you have the floor.
Thank you very much, Your Honors. Mr. Witness, I know you are tired. I'm going to just take a few more minutes of your precious time. Please focus within these few minutes, and I will have later on no further questions. Today, you have been asked a few questions by the defense concerning whether you heard the name of the accused at any point when you were held in Slash. And I would like to clarify this issue. Mr. Witness, I'm finishing my questioning. Just one last on this. Do you confirm what you told us yesterday on this meeting with that person? That
I really cannot follow with this anymore. I'm upset and I just can't listen to anything anymore.
I will ask the prosecutor not to continue with this point. I think you have made clear what your answer is.
I think it has been exaggerated. You've called me here to take me to the hospital afterwards. You haven't called me here for any other reason, and this other side was even worse. They were asking me 10, 15 times for the same question. It's a shame. It's embarrassing. I haven't seen such a court with my eyes before. They're asking me 30 times what for the same thing. I'm really fed up.
Mr. Witness, thank you very much. I don't have any further questions. Then this will conclude my redirect examination. Thank you.
Thank you, Mr. Prosecutor. Mr. Witness. Mr. Witness. I understand that these 3 days have been very tiring and very long. But your
very long
participation as a witness is really important, and everybody should be in the position to ask you questions about a very serious allegation that is made to the accused in this case. So I ask you bear with us a little bit more, and then I hope it will be over. Yeah. Victims' Counsel, is there something you would examine the witness and is there something you would like to ask the witness, and how long do you need, taking also into account how Mr. Witness is feeling? Although that should not preclude you from asking questions.
Thank you, Your Honours, and thank you, Mr. Witness. I don't have any further questions at all. There is maybe one small thought. I think what Mr. Witness just said affirms the need to avoid repetition.
Okay, but should we discuss that at a later stage?
Yes, absolutely.
Not now.
Just, okay, yeah, but no questions from my side. Thank you very much.
Madam Court Officer, can we revert to public session?
Your Honours, we're back in open session.
Thank you, Madam Court Officer. I turn now to the defense. Do you wish to proceed with the rejoinder examination of the witness? And if so, how long will you need?
Yes, I wish to, and I wish to do that in private session, and it would take about 7 minutes, depending on the answers of the witness.
Thank you, Defense Counsel. Madam Court Officer, can we revert back to private session, please?
Your Honors, we're back in open session.
Thank you, Madam Court Officer. We will have a 5 minutes break, and then we will meet each other again in the courtroom. The hearing is adjourned.
All rise. All rise.
Please be seated. Okay. What we will do now is not continue the I will put it on, but what we will do now is not continue the hearing. We will continue tomorrow at 11:30 for reasons that are both of a logistic reasons, that we cannot have the court longer than 4:30. That means that we have another 20 minutes, and before we then get started would be 15 minutes, and I don't think that I want to do that in that way. And also for reasons for the witness, so he can have, and that's the most important one, that he can have a rest. So that is for now. I look at the specialist prosecutor's office if there are any anything you want to raise in general, not.
Your Honor, no submission on our part for now.
Okay,
thank you.
And the Victims' Counsel?
No, thank you.
Defense Counsel?
Nothing, Your Honor.
Okay, thank you. Then we will resume tomorrow, and I will thank the parties, of course, and the Victims' Counsel and the registry for their attendance. I also wish to thank the interpreters, the stenographer, and the audiovisual technicians and the security personnel for their assistance today. The hearing is adjourned, and we meet tomorrow at 11:30. So.
All rise.